All rise. The Court of Appeals Division 1 is now in session.
Please be seated. This is the time scheduled for oral argument in our case, BHB Capital versus Zeman. Our case number is civil 13-0373. Each side's been allocated 20 minutes for oral argument. If the appellant desires to reserve any time for rebuttal, you may do so. There's a clock on the podium that shows how much time you have left, including your rebuttal time. So you have to manage your own time. To assist the parties, you should be aware that we have reviewed the record in this case, reviewed the briefs, reviewed appropriate statutes and authorities, understand the issues, and have conferenced the case. Finally, while each side has 20 minutes, you don't have to use it all. If you're done speaking, you don't have anything to add, we don't have any more questions, feel free to sit down. Finally, you should be aware that we are audio and video recording these proceedings. So when you step up to the podium, say hi to the camera. And please clearly state your name and who you're representing. And with that, Mr. Laird.
Judge, my name is Brian Laird, and I am here for the appellants, Brian and Patricia Zeman. This case has a little bit of procedural knots to it following the motion for summary judgment, but there's a very easy way to fix this, and that is to focus simply on the motion for summary judgment and what happened there. The cases that we've cited in first the opening brief and then in reply, Comerica and the Thrusting case are pretty much as on point as you're going to get.
I think the Thrusting case is sort of the landmark case after Armed School, isn't it?
I believe so. And
A great case.
Who can argue with Thrusting?
Nobody's
Fabulous.
challenged it yet.
So well written. Oh my goodness.
And I don't think anybody will, because the Thrusting case is right, and it correctly interprets Orm School. And Orm School also mentioned that you don't get out of your burden of proof by being a plaintiff and filing a motion for summary judgment. And that's what happened here. Here you've got this breach of contract, many claims brought, but basically a breach of contract claim for this motion for summary judgment. The plaintiff is saying we paid for these molds to be manufactured. Actually, a predecessor in interest paid for it, but they were never delivered. And the plaintiff relies only on a single sentence in their verified complaint in support of that element of their claim.
They can rely on the verified complaint for summary judgment purposes, right?
They certainly can.
Okay. And then your client has an affidavit.
That's right.
And the affidavit says?
We delivered the molds.
Mold.
Mold. Singular.
Okay. So
correct. Correct.
What does that mean?
Yeah.
Or do we know what that means?
Well, we do know what that means from evidence that was subsequently submitted in
If we didn't look at that.
motion to reconsider.
Motion to reconsider.
Motion to
That was-
reconsider.
okay.
And,
What about in the
s-
motion?
Subject to a separate burden of proof, or I'm sorry, burden of review. I understand that. But the bottom line is that Mr. Zeman was the person who was manufacturing the mold or molds. The actual quotation for the mold says one set of molds, two lower, one upper. A set is singular. The real bottom line is
Minimum, doesn't it create a dispute of facts that at least at a minimum one of the molds, if it wasn't plural or singular, was delivered?
Correct.
Because there's at least dispute, at least that's a dispute.
Mr. Zeman's affidavit is firsthand. He says, I did this. I was there. So, yes, it absolutely does create that.
Isn't it
And-
also
I'm sorry.
potentially created by the letter that the person, Wyman back from Simpex sent to
Yeah.
Mr. Martinez saying that, although it would be hearsay, no one objected to it, that Simpex had been informed that everything was delivered to Plum Crazy and a test was run on the equipment.
Yes, it does, and that's exactly why the Thruston case is so important here. And in Thruston, the court exactly pointed out that you can't, as counsel, just go in and say to the judge, we're entitled to summary judgment, and we're not going to give you evidence that's relevant to making that determination. And the plaintiff's counsel had that letter. They had the photograph.
Usually, I mean, this has been a constant concern of mine, it's my picadillo, is that usually when a defendant comes in and says, there's no evidence in the record, they've got to point to something. And if they've got to point to a disclosure statement, let's say, or a response to a request for admission, or an answer to an interrogatory that says, listen, they don't have any, if you look at this answered interrogatory, they don't have a medical expert, they don't have something else,
Yeah,
as opposed to just saying there is no evidence.
Yeah, because Rule 11 requires you to have a good faith basis for your motion.
But
You can't just come into the court.
Right.
Yeah, and say, we don't believe it. You have to have a reason for not believing that they can meet every element.
Okay, but go ahead.
Yeah.
Go
Now,
on.
the plaintiff has their burden of proof, and they have to respond because they have the burden of proof and cite specific evidence that meets each element.
Right.
Here, the plaintiff has that burden when they move for summary judgment. They did not meet that burden.
Well, they have the verified complaint that they can rely on, and because it's verified. The problem is that you then have, as Judge Borley's put out, you have the Simpex, the letter, but we have the affidavit.
Correct. And if you had no opposition, I think you are correct up to a point, Judge. I still do not think, and I think it's really important, practical realities of how these things work for a trial court judge. A trial court judge knows that counsel has a duty of candor to the tribunal. When there is an unrepresented party sitting in the defense seat and there's an attorney on the other side, and the attorney is saying to the trial court judge, in their motion, they were saying, there's no other evidence. The reason no evidence has been submitted is there isn't any. A trial court judge believes that because he or she expects.
But whether she believes it or doesn't believe it, there is an affidavit that says the mold was delivered. Whether
That's
it's
right.
singular or plural, it creates an issue of fact about something was delivered.
Bare bottom line, yes, it does. And I'm happy to answer questions about any of this if there are any. I'll sit down. I'll reserve time for rebuttal if anything is worth rebutting.
Sure, thank you. Mr. Martinez.
Good morning, Your Honors. Thank you. My name is Adam Martinez. It's a pleasure to be here, and I represent BHP Capital LLC in this case. Just as a preliminary note, just for clarification purposes, the appellant was represented on the trial court level at oral argument. So,
But you never sent him, right, the evidence, whatever documents you had, like the photo and some other documents, you never sent that to the counsel, did you?
with due respect, that's not accurate.
Okay.
It was sent to the previous attorney,
The
or the
previous
previous. It was sent directly to the appellant, Mr. Zeman.
Sent to Mr. Zeman if he had counsel.
Well, at the time that the motion was filed, the motion for summary judgment, Mr. Zeman was not represented.
And at the time you filed your disclosure statement?
At the time we filed the disclosure statement, and this is addressed in the briefing to Judge Bartlett and on appeal, the mailing certificate had not been updated. However, the appellant and his attorney acknowledged that they were both in receipt of the disclosure statement at the time of oral argument. So they both had the information.
It was fairly new counsel, correct?
It was fairly new counsel. I think it was
Or
two months, maybe.
He or she is trying to get up to speed.
Right, and I think that brings us to an important point. The previous attorney, Mr. I think it's, Sergeant, I think is what it was.
Mr. Sergeant.
Yes.
He never contacted me or anyone else and asked for some type of extension saying that we weren't ready. In fact, if you review the transcript, Judge Bartlett was actually prepared to recuse himself from the case when we arrived for oral argument. He was under the impression that he had some type of conflict because he was a customer of a Mr. Zeman who owned a gun shop. He represented a Mrs. Zeman who had supported him politically. And he said that if this is the same relationship, he's going to recuse himself. And Mr. Zeman was there with his attorney at oral argument and said, it's not the same Zeman. And so his counsel informed Judge Bartlett, this isn't the same Zeman, there is no conflict. And then Judge Bartlett asked the parties, well, would you still like me to recuse myself based upon those statements and based upon the fact that I haven't had a chance to read everything in detail? Both parties agreed to move forward, said a delay is not necessary.
Mr. Martinez, let's do this. Let's focus on the motion papers
Okay.
and what happened on and before the argument. And let me share with you my concern.
Sure.
When the issue before us, I think, is very straightforward, is did Mr. Zeman present a triable issue of fact? That's all we're looking for. And here, when I look at the motion that BHB filed, I see that attached to it is the simplex letter. Judge Portley mentioned it. And in that letter, Mr. Weinberg,
I think it's Wierenbach.
Weinberg, thank you, states that the parties was later informed by the parties to the agreement. This is the parties being Mr. Zeman and BHB, that the 2 lower and 1 upper modes were delivered to Plum Crazy and a test run was completed on the equipment. Now, insofar as he is referring to the parties, which includes your client, it might not be hearsay, and in any event, there's no motion to strike, and your client submitted this letter for its motion. And then Mr. Zeman filed his own affidavit in which he said, I delivered the mode. Now, one can debate whether it should have said modes or mode, because as your colleague says, well, it was a set, and normally we talk about a set in the singular. But either way, when you put all that information together, it just strikes me that you look at this and you go, hey, there's a triable issue of fact here as to whether Mr. Zeman delivered what he had promised to provide.
Well, I don't think so, and here's why.
Okay.
When the verified statement here is not just a bland sworn statement. If you review the verified complaint, it's very detailed, and it's a narrative of what happened between these parties. And in that statement, the issue that's discussed is what are referred to as lower receivers. That's the product. And that's the product that was at issue the entire time that this issue was before Judge Bartlett. It's not until after summary judgment was entered that this issue of lower receiver extension is raised. And these are two
I don't think
very different parts.
Judge Norris was talking about that. In your motion, in the statement of facts, you have the quote from Simpex says, a new set of moles, 2 bottoms and 1 top. The Simpex letter says, we understand you got what you paid for. Mr. Zeman says, I delivered the mold. So it's not just a matter of whether you're talking apples and oranges, but whether or not a jury would clearly understand this issue, or whether or not they're going to have to figure it out with more information. Because there seems to be, Mr. Zeman says he delivered something for the $65,000, and the question is, and the inference is, what is it? Whatever it may be. And that's the question of fact.
Well, it could be if you presume that the molds that Mr. Wierenbach are referring to are the molds that are at issue in this case.
But we don't know, because we don't have anything else to tell us whether they are or aren't, other than the verified complaints that says we didn't get them. So if we didn't get them, but two parties say you got them, and one of the parties was creating the contract, there seems to be a question of fact.
Well, in order to create a question of fact, there has to be something to dispute.
Your own letter written to you creates that dispute.
How does that create? I mean, well, I don't think it creates a dispute because you would have to assume that that letter is that what the third party is saying his understanding is accurate.
You filed it. You provided it to the court in support of your own motion.
The inference is that it does.
Remember, counsel, on a motion for summary judgment, on review, and even at the trial court, the court has to bring all reasonable inferences against the move-on. So we look, trial courts, and we look de novo, is there a genuine dispute of fact? Interpreting every fact, giving it all reasonable inferences against the move-on, against your client. You file a motion, you attach a letter that says the molds were delivered. Molds were delivered. You got what you paid for. You rely on your verified complaint, which you can do, saying, no, I didn't. The other side files an affidavit saying, I delivered the mold. The inference is there is a dispute of fact. The inference is that the molds or a mold or something that was supposed to be delivered was delivered in part or in whole. And that is, by all definitions, a genuine dispute of a material issue of fact, which precludes summary judgment. Why am I wrong on that?
Well, I think it's an overly broad perspective to have. I mean, it's like saying that just because a mold exists, and that a mold was delivered, a mold that there is a genuine issue of whether that mold is the same mold that was discussed between these two parties in the agreement. And none of the briefing or the pre-summary judgment or including summary judgment briefing discussed that as being the case.
But do you understand there's a reasonable inference that if the seller says, I delivered the molds, you have them. The manufacturer says, I delivered a mold. You say, I don't deliver the mold. Given the standard for summary judgment, we're not talking about a jury trial, okay?
Sure.
We're talking about summary judgment. The inference has to be something that was ordered was delivered. And therefore, there's a genuine issue of material fact, genuine dispute about an issue of material fact. To say that, well, we just don't know, I mean, that would require us to say, well, gee, that we have to interpret all the facts most in favor of reasonable inferences, most in favor of the move-on, your client. And we can't do that, and neither can the trial court.
No, and I'm not suggesting that the
You can
inference
only do
is...
that after trial.
Right. That's right. After trial, if the jury comes back and says, they didn't deliver the right molds or all the molds, we will interpret that in light most favorable to affirm the judgment.
Well, I agree, and I'm not suggesting that the inferences need to be or ought to be withdrawn in favor of the plaintiff. I'm saying that when the plaintiff presented all the information, that it identified exactly what the molds were at issue. And the defendant never objected to that or never said that, oh, no, that's not correct. I delivered those molds, and here's what they are. They're this specific type of mold. They were delivered on this date.
Well,
and
you want a level of specificity that, I mean, as I hear you saying that, it's basically you would have liked Mr. Zeman to have said, okay, on such and such a date, I delivered this mold. It was this shape, size. It had this file number on it. It was blah, 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 detail, detail, detail. And I don't know of any case that says if I'm sued, if I agree to sell you something and then I don't give you what I said I'm going to sell, that we have to have that level of detail on a summary judgment motion. I don't know of any case that says that.
I don't know of any case that says that as well, and I'm not suggesting that level of detail. All I'm suggesting is that there has to be something specified.
So let's say that you were in opposing counsel's shoes, okay? What do you think needed to be specified here?
I think what needed to be specified is that the lower receiver that was being referred to in the briefing was delivered.
So he needed to use the words, "I delivered the lower receiver."
Right. This is a case about molds. I imagine there's innumerable different types of molds that
Oh,
can
I'm
be
sure
at
there's
issue.
thousands of them. I mean, thousands of them.
And
But
I
there's
think
a
what
contract here. There is a contract that says specifically, well, relatively specifically, what was the deal. There's a simplex letter that talks about what was provided, that your client provided on summary judgment, and then Mr. Zeman says, "I delivered the mold." I mean, when you look at all that together, it appears to be talking about the mold that your client ordered, but even if there's some ambiguity or uncertainty as to which mold we're talking about, that's a jury issue too. I think that's what Judge Farley was saying.
Right. I think that's what he's saying as well. I just don't think that's what the issue before this court was. I think to say that is to say that if these parties had done business previously, for example, and that if some previous mold had been delivered, that the fact that that previously mold had been delivered creates a genuine issue of fact in this case.
But on summary judgment, trial judges are not to assess credibility. That is not before them. And you make a good point about course of dealing, and maybe there could be some confusion about which mode I've delivered, but that's a credibility issue. And that's not something that is resolvable in summary judgment.
One of the other things in the Simpex letter that at least concerns me is the statement that the details about the mold would be handled by Mr. Maxwell and AO Engineering, and yet the only thing we have from AO Engineering is I delivered the mold, which you've got the quote from Simpex, you've got their letter, and there's a creation of maybe whatever Maxwell and Zeman agreed to was something else, but we don't know.
Right.
We don't know what Mr. Maxwell would say, and someone may depose him or call him and clarify that, but at least Mr. Zeman says, hey, I got my money, I gave you the mold.
Right. And I think,
what else do I need to do?
sure, I understand that. I think in this case, to draw the inference from the Wierenbeck letter to say that it's possible that mold being referred to could be the mold at issue in this case is to ignore what the parties actually had discussed at summary judgment.
Well, no. We look at this independently. We don't care what happened at summary judgment.
Well, okay. Then I think ignores what the parties understood the agreement to be.
But what the understanding may be isn't in the moving papers. Okay. And it's compromised by the Simpex letter.
Well,
And you submitted it.
no, I understand, and we submitted it because that's what it was there for. It was to demonstrate not that these molds had been existed, but for any, at least in any event, no one's hiding anything here. This is what the letter suggests.
We understand, but that's the creation of the fact that ultimately, whether with some more information, another summary judgment is appropriate, or there's going to have to be a jury trial with respect to this issue.
Well, but I think it does ignore the fact that if that were an issue of fact, and the non-moving party is in possession of that information, if they believed or would ever argue contrary to what the moving party is arguing, why wouldn't they raise that issue and say, we have in our possession the very letter that proves we are right? And that's not what has ever happened here, not until after summary judgment has concluded and after the issue, these new facts have been raised.
But summary judgment's not a discovery tool. You could have deposed Maxwell, you could have deposed Zeman, and I understand there were some requests for admission. I don't know if there were any non-uniform interrogatories sent, but ultimately at trial you have the burden of proof. And So at summary judgment, you have the burden of proof.
Sure, and I believe that burden was met. If the moving party alleges there's a contract that's been breached, and the non-moving party doesn't dispute that there's a contract, and the only
And says, I haven't breached it.
and the only statement that says I haven't breached, but produces nothing, I don't know what else the moving party would present other than
Create an
the
issue of
statement.
fact if I agree to sell you widgets, and you pay me for the widgets, and then you sue and say, Norris didn't give me the widgets, and I say, I gave you the widgets. I performed. Well, that is an issue of fact. You may not like it because maybe you know behind the scenes that I am a liar. But nevertheless, as far as a trial judge is concerned, he doesn't know that, or he or she doesn't know that. And that's a credibility issue, and a jury's going to have to decide that.
No, I understand the point and the argument. I think to make a conclusory statement in response leaves something else open, something other than just he said, she said. I don't think that's the standard for summary judgment. Otherwise, no summary judgment issue would ever be granted.
I know this is not a personal injury case, but we have cases out the yazoo in which a person driving a car is in an accident with another person, and they each dispute who caused the accident because the perceptions are different. And the plaintiff says the defendant caused it, and the defendant says, no, the plaintiff caused it. And that generates a jury trial, or at least an issue of fact that warrants a jury trial. This is really no different.
Well, with due respect, I think it is different, but I understand what you're saying, the thing I would point to is the fact that this isn't an issue like a personal injury case where one party says, I didn't cause the accident, but I was there in the intersection and I was waving a gun or whatever the case may be, which is more like what you have here. You have all the underlying facts being conceded and admitted to, which gave Judge Bartlett all the reason to enter summary judgment. And then after summary judgment's entered, then you have someone who failed to respond to non-uniform interrogatories which were issued, requests for admission, all the discovery that could have been done, all of a sudden saying, oh wait, there's more discovery that needs to be done, and there's this new issue. I'm going to change the facts entirely from the issue that we were discussing previously to a new issue, which is something that wasn't before that court. And I think the point of the cases that I cited is to say that if you're going to raise those issues, you need to raise them. You can't just raise them or not raise them, and otherwise they're waived. So I think that's the issue here, that if there is some type of evidentiary deficiency, then the resolution would have been for either Mr. Zeman to raise that issue on summary judgment or file some type of motion to strike, neither of which happened.
Counsel, let me just change the topic a little bit.
Sure. My time is short, so.
That's all right. We're not bound by the clock. You are. If we have a question pending and you run out of time, you can still answer it. Two questions, I guess. In the trial court, you indicated that all of these different claims were alternative theories for the same recovery. Does that mean they've all been abandoned?
No.
If you prevail on this?
Well, at the trial court, there's some background there. For all purposes, this had resolved the case for BHB, and so there was no further, litigation that was going to continue.
So if we reverse, you're not saying the claims are abandoned?
Correct.
Okay.
That's correct.
The other question I have is, at least as I read it, the transcript seems to indicate that you told the trial judge at the hearing, the conclusion, the reason why Mr. Zeman doesn't produce any evidence to substantiate his statement is because there is no evidence. At that point in time, did you have a photograph showing the molds in place? Or purportedly showing the molds in place?
I had in possession the photograph that Mr. Wierenbach thought or argues or says that he thinks that that's his understanding, that that's what was delivered. Once that photograph was received, obviously, I go to my client and ask them, is this what it purports to be? And when I receive the answer no, well, then we move forward.
So you can then tell the court there's nothing?
Correct. And what I'm saying is that there's no evidence that Mr. Zeman is offering in support of his claim. In other words,
There is no other evidence.
Right. There is no other evidence that he delivered the lower receiver molds that
You
were
said
ordered.
you said the reason he doesn't produce any evidence to substantiate his statement is because there is no evidence.
Right.
But there's at least a picture that one person to this underlying action thinks shows the molds have been produced.
Well, I think that presumes that they are what he's saying they are.
Right.
So, yeah, if it's determined.
At least somebody thinks, somebody to the underlying contract or the underlying agreement thinks that these are what they are. And you tell the judge there is no other evidence.
I think that's reading in a lot to what that third-party letter is saying. You would have to have a whole separate evidentiary hearing on what was involved in that. The photograph is not what it purports to say it is.
Your client.
Well, yeah. Well, and according to my client, and there's no evidence to suggest that it is at this point.
Except that one of the parties thought it was.
Well, you'd have to know what that mold was that was in there,
Okay.
and that would be the issue in that.
Is there any evidence in the record that PCF manufacturing is still around? Or is this just the assignment that you took, that your client took?
I believe it's just the assignment. I know that the parties the people are still around. It's not, I think they're just two people. So, yes, I believe they're around.
Okay. Thank you, Counsel.
Thank you, Your Honor.
Do we have any questions? Anything else?
I'm taking a chance here, but I'm going to go ahead and
You are.
try. Been around long enough. I should know better.
I was going to say, Judge Bill Sargent once said.
Yeah. I want to clarify a couple things, if I may. And I'll just filibuster a little bit, if you give me that leave. Just so that the court understands, because we've talked about who the parties to the contract were and that background. So Mr. Zeman is the guy who makes these molds. And there's these people, Simpex and Mr. Wyrenbeck out in California, they make the machine. Mr. Zeman essentially retrofits molds onto this pre-existing old machine that Simpex and Wyrenbeck refurbish. The original party, the purchaser, was Mr. Maxwell, who was PCF/Plum Crazy Firearm. And the plaintiff in the case is BHB Capital.
We know that.
Okay.
Yeah.
BHB Capital
We've
claimed
got it.
it.
Thank you.
Assignment of this claim.
Exactly.
Right.
Okay.
Yeah.
I just want to clarify, they weren't the original party to the
We
contract.
understand.
Okay.
But Simpex will.
And then the other thing I'd like to point out is that there's nothing in the record where the plaintiff, BHB, says no regarding the photograph and the Wyrenbeck letter. There's simply nothing there's not anything.
Not an affidavit or anything from BHP Capital?
There's nothing that says, I checked with my client, and he says this is not.
Understood
Okay,
that.
thank you.
Anything else?
That's it.
Okay. Thank both counsel for their arguments. We will take this matter under advisement and issue a decision in due course. With that, we stand adjourned.
Thank you.